to a live episode of Surviving the Survivor. We bring you the best guests in all of true crime. Don't forget to subscribe and smash that like button. Here's your host, Emmy Award-winning broadcaster, Joel Waldman.
What's up, STS Nation? Welcome to a special live afternoon edition of live coverage of Donna Adelson inside a Tallahassee courtroom, if she actually shows up. This is Surviving the Survivor, the podcast that promises to bring you the best guests in all of true crime. And we are live on a Tuesday that once again feels like a Monday. Welcome in, everyone. We've got the Professor Joe Potuto. Unless you've been living under a rock, you know who she is. Professor Emerita, University of Nebraska Law, a legal scholar in her own right, just like Dan Markell. And she has taught all over the country. She has taught law in very prominent law schools. Let me just say, up to the last 30 seconds, still a ton of confusion about what's going on, what's happening. The voice of reason, Joe Potuto, will help us break this down. And hopefully famed Tallahassee criminal defense attorney, R, the letter R, O-U-R as well, Timothy Jansen, who is also a former federal prosecutor. He's supposed to jump on to help us out with this. But Joe, and I've been in touch with Jeff Burlew. Shout out to him. If you guys aren't following him, you're missing out on Adelson coverage. He covers it for the Tallahassee Democrat. He's in the courtroom today, and he always gets really great information. So what we are kind of learning in the last little bit of time, and courtesy of WCTV in Tallahassee, we should have this live event. You'll see here, right here. I'm going to pop it up just so you don't think I'm lying. Stand by for a live event. That is WCTV, the CBS affiliate in Tallahassee, Florida. I'm going to leave it up there because it just makes me feel better. It's kind of like a pacifier. It calms my nerves. Special thanks to AA Legal Focus and True Lifestyles and Jeff Burlew from the Tallahassee Democrat. The other two obviously are not, for all the help today with these motions. It takes a village. Asian American Legal Focus. If you haven't followed her YouTube channel, it's great. Same with True Lifestyles, otherwise known as Susan H., who helps us all the time behind the scenes, even when we're not asking for the help, which is amazing. So thank you all. So Professor Joe Potuto. So the way I understand this, and I think you do too, today should be relatively short, like a case management type hearing. And then February 26th, which I guess is 2 weeks away roughly, there's about 2 or 3 hours set aside to hear some motions that were just filed. Am I correct about this?
Yes.
Okay. So the motions, I like your long thought out answer. It was great. So a couple of motions were filed. And I'm just gonna read a portion of one. And again, thanks to Amanda behind the scenes. I don't want to bore anyone, but we've got a couple of kids home sick. It's been chaos, but that's our business, sort of your business, because we're all family, but it has been hectic to say the least. But I just want to pull up something that Super Planner just sent me. Amanda, Super Planner. This has to do with one of these, the motion actually asking for a bond hearing, Joe Potuto. Now,
Right.
we reported last week about an assault against Donna in the shower, which my sources told me happened 7 months ago. But Jeff Burlew of the Tallahassee Democrat reported it happened a month ago. Fancy also had some reporting on that as well. But I'm going to read directly. There's sort of a headline within this motion for a bond hearing. They're giving reasons, and one of them is described as physical abuse, which is what Donna claims she endured. And it says, one of the first acts of physical abuse by another inmate took place while Miss Adelson was showering and was of a, close your ears, everybody, or open them, and was of a sexual nature. She thought she was alone in the area while she was showering when all of a sudden she felt another inmate run her hand up her entire spine from just above her buttocks to the area of the neck. The inmate then asked Mrs. Adelson if she liked it, and in response, Miss Adelson, very frightened, began to scream, which caused the aggressor / inmate to leave the area. Mrs. Adelson did all she could to avoid this woman during the remainder of that inmate's incarceration at Leon County Detention Center. So, wasn't just an assault, but it was apparently a sexual assault of some sort. Joe Potuto, how does this change, if at all, the dynamics? Look at the professor. She got reams of paper as expected.
I'm reading the motion again.
Yeah, look at that. But how, if it in any way, does this change the possibility of a bond hearing? Someone said, "Hey, this is clickbait. There's no way she's getting out." I don't think she's getting out, but we've got to address the issue. We would never clickbait you guys. But go ahead, Professor.
I don't think it affects it much at all. Prison or jail is not always the safest place in the world. I read this motion on the bond that they're going to be hearing on the 26th. And a lot of what's in there is a description of what it's like to be incarcerated. There doesn't seem to be anything that's unique to Donna Adelson as
here we go. I'm gonna
at a jail.
Here we go, everyone. I'm sorry,
we
Joe.
We do object to
Sarah Catherine
as far
Dugan
as all of
speaking.
these witnesses. They sent us about 24 hours they need to depose several witnesses. We worked with them to get times that we are available, and we'll continue to do that. Some of the witnesses have never been deposed before. We obviously have no objection to that. Some of the witnesses have been deposed by prior counsel of other co-defendants. Looking at the rule 3.220, it says any cases, including ones with multiple co-defendants or even consolidated cases, no one should be deposed more than one time unless good cause is shown. If it's something that pertains to their client that's, new, we don't have any objection to that. But as far as just setting these people for hours and asking them a lot of the same information that's already been said in prior depots, we would object to ask and answer and not want those people to have to be deposed again. And then as far as the folks that they named, I think it was Agent Sanford and Corbett and Rob Adelson, that Donna Adelson's former counsel has deposed. As the court said, we would ask that good cause be shown. We're fine with that being ex parte and in camera, but we would ask to have that done, be able to weigh in on that from our side as well in those same situations, and object to them being deposed again. If there is some new information in Corbett's presentation as of April 30th that they didn't know about before, we would absolutely be fine with him being deposed on that information, but just not having to go back through what's already been said with hours and hours of depots and prior testimony.
Tim Jansen is in the front row taking notes.
Moving this trial date if it does not need to take place. April 30th is the discovery cutoff. We're going to leave that in place for now. Everyone is to work accordingly up to the deadline. If it has to be extended, it will, but there's still 2.5 months to that point, right?
Yes, sir.
We'll drop the motion, Judge.
Yes, sir. And, certainly, by way of a brief response, and I will be brief, the rule cited by the state contemplates that the co-defendants are all being tried at the same time or have all been arrested. It defies logic to believe that
these trials have been spaced out. They are not co-defendants that are linked by one information.
Thank you very much, Your Honor. Lastly, this morning I provided a proposed order to the court from the August 30th and September 6th motions in limine. I prepared those based on the transcripts that I had prepared of those hearings. I provided them to the state twice over the last month and had not gotten a final answer. Does Your Honor want me to submit the transcripts from those hearings?
You can do so. I'll review them. Ms. Dugan, as the proposed order, is the state objecting to it, or you haven't had an opportunity to review it?
I did speak with Ms. Kaplan about that, and we reviewed it. We don't have any objection.
Very well. I'll still review the transcripts to ensure it is accurate, but trust but verify. Go ahead.
Yes, sir. There are some additional motions to suppress and a handful of motions in limine. I'm hoping to get the motions to suppress filed in the next week to 10 days so that those can be heard properly. The motions in limine, we're certainly going to try and get those filed early to mid-April so we can get those heard as well. I just wanted to let the court know that the motion to suppress that we filed last week is not the only one that's coming.
I believe the date that we're going to have for the pretrial motions, that was going to take place on Friday, May 16th. Obviously, more that can be heard prior to then will lessen the burden on that day, but anything that's still outstanding, that's the day it's going to be heard before we move into trial posture.
Yes, sir. Certainly with the scope and breadth of the motions that we are working on, we'll try and get those on your calendar much sooner. And lastly, I wanted to update the court on the expert that has been retained. I spoke with them for the motion for change of venue. I spoke with them yesterday, Mrs. Fulford and I did, and they are intending to provide us with the end product by the end of the first week of March. And as soon as we have that, we'll be providing that to the state and get that set. Provide that to the court as well and get it set for a hearing.
All right. Concerning this report, and I'll leave this to your judgment, but do any of these matters need to be filed under seal to alleviate essentially the issue you're complaining of for the motion?
Yes, Your Honor.
Very well. Ms. Dugan, does the state have anything to raise today?
No, sir.
Upcoming through the deadlines, as we've spoken about before, the discovery deadline will be April 30th. We'll also have one last case management on March 25th at 2:30. As needed from there, we'll have different hearings on motions, and we'll continue to move to June 3rd.
Thank you, Judge.
Thank you, Your Honor.
We are in recess. Let's move on with calling the other matters this afternoon.
Ascended Adelson.
Is that all she wrote right there, Joe?
Yep.
Wow. I'll keep it up for a second, just muted here. That is not the courtroom where the trial will be held. That looks like 3B. I think 3G is the courtroom. So short and very sweet. And you saw Tim Jansen there inside the courtroom, which is why he wasn't here. Just a couple of minutes worth of a hearing. Donna Sue Adelson notably was not there, not present. But Joe, when we picked it up, it was Sarah Dugan essentially talking about 24 witnesses to be deposed. I didn't quite catch it all. That's all I heard at the very beginning. What do you make of that?
Yeah, I didn't hear it all either, but it sounded as though the defense lawyers want to redepose a number of witnesses. And Sarah Dugan said they had no objection if the defense can point to additional information they need to get, but just to go back and redo what's been done, they had an objection to it. Tim, you were there. You might have. That's what I thought I heard.
Yeah. So Tim,
I was.
look
Yeah.
at you. By the way, Tim, look at you in the courtroom. You didn't even tell us. I don't think I knew that. So kudos to reporter Tim, a top-notch correspondent. But Tim, we picked it up a touch late, where Sarah Catherine Dugan was talking something about 24 witnesses still to be deposed.
Right.
What was that about?
Well, no, she said they wanted 24 hours set aside for depositions of these witnesses. And they're wanting to depose Pat Sanford, Chris Corbett, and Robert Adelson, the son. And some of these people have already been deposed. So the state was saying, well, wait a minute, they're co-defendants, you can only depose one time. And the defense argued, wait a minute, they weren't really co-defendants. And the judge took short order. They're not co-defendants. They weren't co-defendants at the time. So when you have co-defendants and someone sets depots, you all have to go at the same time. You can't piggyback them just to delay it or go get multiple depositions. So I think they're going to be able to depose Corbett and Adelson and Sanford. It's funny at the last part, they have a couple, well, they did agree to some stuff, like some of their witnesses, like Marcia Rodriguez, who took Wendy's phone. She would be the person to lay the foundation. They're going to stipulate to that because she's out of the country. They're stipulating to perpetuate the testimony of Dr. Clark. I think that's the ME. And they're agreeing that they wouldn't have, the defense lawyer at the time didn't ask any questions and they wouldn't have asked any either. So they were okay with that. Apparently Corbett is getting a new presentation that's going to be fancier and nicer. Sarah said, going to be prettier and nicer.
I thought the
But
other one was pretty good.
yeah, but they haven't finished it and give it to the defense, and the defense is entitled to it. The discovery deadline is April 30th, so they're still within the time frame for that. She said there's no substantive change, no new information, so that shouldn't be a problem. But they want 24 hours set aside by the state to depose these three witnesses.
And Tim, how soon would that happen, do you think?
Well, they got it. The deadline date is April 30th.
Yeah.
So they're going to need to do some of that rather quickly. And you heard the judge, we're not moving this trial date. So you need to make sure that you understand you got 2.5 months to get this completed.
Yeah, Tim, let's start here. What was the kind of the vibe inside the courtroom? Obviously, it was a super quick hearing, but Everett definitely looks like he's not messing around. He even said trust but verify at one point. So he's making sure everything is dotted and the T's crossed. But what was the mood like in there?
Well, I can tell you all the media were there. A lot of people I know from podcasts were all in the front row. The Democrat was there, the TV was there, a couple podcasters were there. The court is it's a normal case management. So lawyers, I actually got to go up right before Donald, and I had like 9 cases on the docket. So I got mine done. And they had these issues come up. There's some motion in limines, and there's some more motions coming. So that's important to know. When the judge says trust but verify, that means I trust you, but I really don't. After what's going on with this case, I'm going to double trust you or double trust myself, meaning even if you tell me something, I'm going to double make sure those transcripts are proper. And if you remember, Joel, they filed that motion asking for a new trial. And I said, well, why did they do that, not filing under seal? Because now they're complaining about the same thing they're doing. So the judge today said, well, wait a minute, this motions you're filing, can you do those under seal so you're not violating the same you're complaining of? And they said, yes, Your Honor. So that was interesting.
So Tim,
I thought the fact that
go ahead, Joe.
They say there are going to be a few more motions to suppress was interesting.
Yeah, what do you make of that, Joe?
Well, they've got the one, which is that phone call from the jail where Donna thought it was the phone call ended and she kept talking, which is an interesting motion. I think we'll talk about it at some other time. I think they will lose it, but it does raise an interesting sort of legal question that is not quite anywhere where I think that there's precedent right on point. It's what it means is they think there's other evidence that would be detrimental to Donna's case that they think they have a shot at keeping out.
Well, the way they said it, Joe, they said this other motion is so complex, I'm going to try to get it filed within a week, knowing how complex it's going to be. And there's motion in limines coming that obviously should be filed under seal.
It's not good when you have a motion that's very complex.
No,
I mean,
a
usually
motion
if
to
you've got a
suppress.
good legal issue, it isn't complicated.
Yeah.
Yeah. So, I mean, this was an incredibly short hearing. My thinking for today is that we kind of do the show as we're doing it now, because I don't know how much more. Tim, do you have some time now, or you have to? Are you good, Tim?
No, I'm good. I'm good.
Okay. So, by the way, he said there'll be another case management hearing, March 25th, 2:30, and as Tim just mentioned, April 30th, and Joe mentioned, is the cutoff for discovery. It sounded like maybe, Josh Zellman and Jackie Fulford, Donna's attorneys, were angling to push continue the trial past June 3rd, which is the scheduled start date. And Judge Everett was having none of it. Of course, I lost half my notes on this, but Tim, I do have some remaining. And by lost, I mean, I don't know how to use my tablet. But Tim, I said, I read this aloud to Joe, and, we talked about that assault in the shower. But it turns out Donna is claiming it was an essay, a sex assault, that an inmate ran her hand
No,
up.
they're two separate ones.
Oh,
They're
two separate ones. Okay. Okay, great.
One-
So
Yeah.
so
One ran
please
her. Yeah, one ran her hand down her back and
mhm.
said, "How did you feel? Did you like that?" And she screamed, and the person ran. And then apparently another one is where she was hit on her shoulder, where she got hurt. And then there's a third one where she said she hit a rusty nail and got bleeding, and she couldn't get a Band-Aid for like 24 hours or 48 hours.
And we're going to get to the ear canals in a moment, which is what I'm looking for here. But
She's got the breathing issue too. Let's not forget the breathing issue.
yeah. So Tim, first to you. I mean, what you just described, I didn't realize there was now 3 assaults that she's claiming. And I thought those 2 were one, but one apparently was like sexual advances in the shower. Tim, I did not realize Donna Adelson still had her mojo at 75. What do you make of that, Tim? I mean, and I asked Joe this, does this change does this change Judge Everett's outlook on this? Someone said, hey, there's no way she's getting out on bond. Why are you even talking about it? Does this change the playing field at all?
Listen, does everybody know jail sucks? Yeah. Does everybody know jail is not a good place to be? Yes. Does everybody know when you're in the shower, that's most likely where you're going to be touched or possibly sexually assaulted? Yes. Now, just because she's 75, wealthy white woman from South Florida, doesn't mean that the conditions should be better for her than anyone. The question is, can they protect her, get her the medical needs she needs, and have her ready to participate with her lawyers? She was on the phone today. She was talking fine. There was no breathing problems. They can put her in solitary, which what they've done. That will protect her. When she leaves that cell, she leaves with an escort. Everybody else on the wing has to be in their rooms, so she can take a shower by herself. She can be on her phone and close the door so her lawyers can hear her on her tablet. That's perfectly fine. The medical will be taken care of. I just don't, she's not going to get out on bond. I don't see it. I don't see a basis for the bond. And whether someone rubbed her back in jail, I can tell you, I'm sure that's happened a lot. I don't think it matters the age, right? I think people in jail try to find comfort many different ways. And at her age, we don't know who the person was. We don't know if it was someone similar age or someone younger. So I don't think that's enough. I think if she was physically assaulted, where she was sexually assaulted and left there and not taken care of, that's a completely different story. But by her own admission, someone just rubbed her back while she was in the shower. She did describe that they tried to get a Band-Aid to her, and they did get attention to her
I
and
did.
told her to cover her hand when she was bleeding, and there was a delay, but I don't think it reaches a level that jeopardizes her health.
Yeah. By the way, someone took offense to my little mojo comment. Obviously, essay is never a joke, but it wasn't meant to be that serious.
Well, one
AA
of the
legal.
interesting
Yeah.
things, Joe, if I can say with
Yes, please.
this motion in particular, is it's very mushy about when things happened. The incident in the shower has no date at all in the motion. One of the other incidents was in October. They complain with regard to access to a lawyer that she's in a pod where she can be overheard and she's in her bed all day, but now she's in protective custody. So that's no longer an issue. And at the very end of the motion, having already said that when she was in the pod, all she could do was stay in her bed all day long, they talk about now that she's in protective custody, she's lost the opportunity to do the art classes, which is directly contradictory to what else they said. It's like they found every little thing they could find and put it all in a pile, and they're trying very hard not to isolate what happened when, and what her situation is right now.
Yeah, great point. And AA makes a good point here. Tim, we don't know if she made it up. One of these things obviously happened a while back. I mean, Tim, what do they do about that? Can they investigate this to try? And by the way, now you can send your hate mail to Fancy and me. Donna probably would have been hit on much more in jail had she gotten the chance to get her arms done, as indicated. If you guys remember in her planner, she did want to get some work done on her arms. But again, you can send that to hate mail at fancyfiction.com, not me. Tim Jansen. What do we do? I mean, Donna could just be, she could be telling the truth. She could be making this up out of whole cloth. How do we know? And how does the judge know?
Well, it could be self-serving statements to get bond, right? If they were so egregious, why didn't they bring these to the attention of their lawyer, her previous lawyers? Why didn't they file a motion to get her removed to a different facility? None of that took place. It seems like it's all trying to come down at once. She was in an annex. She was put in the corner by herself for her protection to give her some privileges. She apparently had two little things for all of her things that she was able to buy from the commissary, 2 buckets. She had it pretty well, and people looked out after her because she's the older woman. So there are people that were in that annex that will probably dispute most of what she's saying. I don't think they can dispute what happened in the shower. They weren't there. But I think they'll dispute that she was harmed or unable to talk to her lawyers. My understanding, she was on her phone with her lawyers all the time. She was talking to her husband all the time. Her
Right.
lawyers came every Monday and spent hours with her. So we'll see what the judge does, but I don't think it raises to a level for get her a bond.
Yeah. So forgive my ignorance here, Joe and Tim. We had these 2 motions filed, the bond hearing, and this phone call that we're going to get into in a minute. But Joe and Tim, are you saying and I apologize, I've got a kid sick with COVID at the moment, but were other motions, I understand, were just filed? These are separate. Is that correct, Tim?
Well, Tim was in the courtroom, but what I thought I heard was the lawyer saying they had other motions to suppress. Tim, yeah. So there's something else coming. There's some other evidence that they believe they have a shot at keeping out. That's what a motion to suppress is. You say that for legal or constitutional reasons, the evidence that the state wants to use cannot be used in evidence at trial against the defendant.
Yeah. By the way, the COE, Space Coast on the West Coast, and Steve Cohen hustling last minute, as well are the mods, and a lot of people behind the scenes who are helping, which is much appreciated. But the COE has made sort of an executive decision. We are going to come back at 5, and we'll have graphics. That's what the COE is working on to discuss this kind of
5 or 5:30, Joe, because
5:30. Sorry, today's if my son can make it, he has t-ball practice. So family first. I should get a giant tattoo on my forearm that says, how do you say first in Italian? I'll get it in Italian. Primo. Familia primo. I'm going to get on my.
So Joel,
yes,
hypothetically, if a motion to suppress the phone call, which I don't think is going to be granted, but if they can buttress that and say, okay, listen, the only reason they knew about her going to the airport and fleeing was because of that phone call, they might be trying to do a motion to suppress the entire trip to the airport and the flight to the Vietnam, claiming it's fruits of the poisonous tree. It's a long stretch, because I believe there was an intervening factor. I think one of the persons she called about hotels called the state attorney's office. So they might be able to have independent evidence that she was fleeing and known where to go get her. But we'll see. Motion to
That's a
suppress
real
what?
long shot.
Motion to
Yeah.
suppress is to keep out damaging evidence.
Right.
So
Yeah.
what's the most important thing they filed a motion to suppress on? The flight and the call, because they know that's detrimental to their case, no matter what she says on the stand.
Look at this, Professor Jansen. I love it. But Professor Potuto, Tim uses the phrase fruit of the poisonous tree, which reminds me of like a Rembrandt painting, which reminds me of my mother and father dragging me to the Metropolitan Museum of Art, which I used to despise because I thought it was boring and I'd rather watch baseball, but that's a whole other story. But what is fruit of the poisonous tree?
Well, the poisonous tree is the constitutional violation. In this case, I listened to your phone call. I didn't have a warrant. I didn't have consent. I don't, I think it's a bad argument, but that's where they'll start. If the defense wins on that motion, then the second question is, what did you learn specifically because of the phone call that you shouldn't have heard in the first place? That's the fruit. And so the fruit is what you learned. There are other rules that come into play as to, even if you learned it that way, is it so far attenuated that it should come in anyway? I mean, it can get pretty technical in terms of how far it goes. But basically, the poison tree is the constitutional violation that's alleged. The fruit are things you learned because of the constitutional violation that you would not otherwise have found out.
Yeah. By the way, we'll go like, since we're going to come back at 5:30 and we're going to have Joe and Tim back, and I don't know if we have a third, but it doesn't matter because these two know as well as anyone. But so we'll go like another 10, 15 minutes because I want to get through a little bit more. And then again, we'll have a full recap at 5:30. And by the way, tonight, no rest for the weary, 7:00. There was a deposition released in the Kentucky sheriff case where he murdered on camera, allegedly, but it's on camera. You see it all in Letcher County, Kentucky, and there's some more information. So Elizabeth Jones of Hillbilly Crime is joining us with General Mark Davidson, and John Tompkins is going to join as well. He's a criminal defense attorney. So that story is fascinating. But Tim here, AA Legal Focus, again, the latest motion is to suppress, as you guys were saying, the 8+ minutes of a recording when she forgot to hang up from the call with Charlie. That is known as sort of the hot mic call. So that is definitely one of them. However, before we get there, let's just go back to this bond motion. This is a motion to set bond and schedule an Arthur hearing. Tim, for those who are not familiar with an Arthur hearing, explain what that means.
An Arthur hearing means the crime you've committed is so egregious that you should not get bond. The court will look at the evidence and determine if the evidence is great and whether there are conditions or factors that will ensure the community for your appearance or safety. It's a two-step. They have to prove that the evidence the state has that you committed this capital offense is great and that there are no other conditions that could ensure your safety or your appearance at trial. The government carries the burden on this, and Judge Everett does them all the time. Usually it's for capital cases, and it's not easy to get bond. Sometimes the state will agree because they don't want to give up their case at a hearing. They have to call a witness. They have to call the investigator. It's like a free deposition for the state. So you're going to see sometimes in these cases, the state will agree to bond or not file a motion to detain and let the court set a bond. I had that happen in a case I had with manslaughter, 2 counts. They decided to not call witnesses and said he's eligible for bond, even though he was previously held without bond. And, the state carries the burden. And I think they've already done this multiple times. So they have to show a change in circumstances. And the question is whether or not her Sixth Amendment is being deprived, her health is at risk, and she can't get her lawyers or see her lawyers. So then the defense is going to have to argue and carry the burden of why that they have to prove they can't. Her Sixth Amendment's being violated.
Tim, this I think is more in your wheelhouse from Annie K here. If the defense is able to keep out video of Donna's arrest or call, wouldn't arresting officers and others testify to details, her reactions, etc.? What about that?
I don't think they can keep out the video of her being arrested. It was at a public place. There's no expectation in an airport, someone videotaping you getting on a plane. So I do not believe they'll keep the video of her getting out.
Tim,
Yeah,
Tim, that's true unless your earlier point, which is that it's the fruit of the poisonous tree, is not operative. Because if you say the only reason why they knew she was fleeing was because of that phone call, and it's because of that that the police were at the airport, then there's an argument, public place or not, that you can't get it in.
well, I think we know that the neighbor called the state attorney's office
Exactly.
when
So you
she
have another
called
way.
and said, listen, she's asking about a place to stay. We thought it was Hinky, so we called the state attorney. They can have a good faith or a third party evidence how they got that information. She'd be at
That's
the
right.
airport.
That's right. Then it doesn't derive from the poison
Right.
tree. It's dependent of it. Yep.
And you would have think they would have added that to their motion to suppress to keep out the video in the motion pending, right?
Well,
They
I
would have
thought
added.
most motions were not well crafted, or in the bond motion in particular, it wasn't well crafted just to keep it all a mush and hope you could get by, because if it was made more crisply, the opportunity to prevail on that motion would be less.
Well, Joe, you're a professor. This is the shotgun approach, right?
I know.
Rather than giving you detailed, clear answers, they threw everything they knew possibly to throw something up and see if it sticks to show you how much they know, right?
And then they have, I mean, I'm sorry to say this, but this is the professor. Sentence fragments and typos, it's not the way you should be filing something.
Yeah, lazy. So Tim, let me read this to you. This is back to this bond hearing issue. And one of the things besides the essay that they list is medical issues of Mrs. Adelson. We're going to have graphics on this for 5:30, but Mrs. Adelson is a 75-year-old female with typical medical issues of aging, exacerbated by the conditions of confinement, hearing problems that are compounded due to a medical issue that cannot be addressed by medical personnel at the Leon County Detention Facility. Prior to incarceration, she saw an ear, nose, and throat doctor every 3 to 4 months to have her extremely small ear canals cleaned out, which is ironic because she has large ears, but very small ear canals cleaned out with proper equipment, as general flushing will not resolve her issue. Severe pain from a pre-existing medical condition in her back and legs that cannot be relieved by the medical care available at the Leon County Detention Facility, and excruciating pain in her left shoulder, down her arm, and into her hand as a result of an injury received during an attack by another inmate at the detention facility. Within the past few months, Mrs. Adelson has begun now experiencing shortness of breath that has reached a level where others comment about hearing her struggle to breath. It should be breathe. This is what Joe's talking about. Undersigned counsel has, these lawyers better know the difference between breath and breathe, Joe. I would not, I would deny the motion based on spelling errors alone.
And grammatical mistakes,
yeah,
yes.
I want to get both your takes, but Tim Jansen, look, she's accused of a hideous crime of murdering an FSU law professor, and now she's, in the process of this being adjudicated, and she is in a jail, which is not a fun place, and it seems like they're complaining about everything, including her ear canals. Did Josh Zellman and Jackie Fulford just jump the shark? If you guys remember the Happy Days episode, is that what's going on here?
Well, if she really had these problems, why didn't Dan file these motions? Where are the medical records where she sought treatment? You get cop outs, you want to go to medical. Why didn't any of them file? She's been in there, what, like 15 months now, 18 months? And now we're first hearing about it? It seems to me more realistically, she wants to get out on bond so she can get her hair done, so she can be more presentable for trial, maybe lose some weight, maybe meet with her lawyers more, see her husband, and try to prepare for trial. But you don't get that privilege when you're charged with first-degree murder. And unless she's in severe medical crisis and they can't provide her medical, they can clean her ears out. They have a nurse at the jail. They can clean her ears out. It's just hard when you don't make these complaints for so long. Now, when trial's coming up, all of a sudden, we're going to put everything on there.
Joe, your take on the ear canals and more?
Well, I'll say one thing. If she needs them done in a professionally distinct way every 2 or 3 months, 3 months from now, there'll be a trial. So this particular condition doesn't require being out on bail to take care of it. I agree with everything Tim said. The only thing I would add is what seems to be happening here is these two lawyers are much more, I don't know whether the word is aggressive, assertive, more likely to listen to what she wants and not exercise any control. Whatever it is, they're doing a lot more of this stuff than happened prior to their being appointed to the case. For good or ill, they're sort of keeping the waters churning more than we saw before. And it may just be she's getting close to trial and she's been in jail a while and, now she's going to churn herself more.
I think that shortness of breath is known as anxiety, possibly. Jared Ross, obviously an attorney and friend in Tallahassee, he has the legal definition of what is going on. He says they have a turd sandwich of a case, and that's why they're doing this. So that is what he learned in Joe Potuto's class. Anja here. Tim, this keeps coming up, but if this call is suppressed, does that change the dynamic or the paradigm here in terms of calling Rashbaum to testify? Because she apparently references him on that call, or at least everyone thinks so.
So if she had a conversation with anybody other than her lawyer, it's not attorney-client privilege. It's been waived. And if she testifies, she can be cross-examined. I think they're going to get it in.
I do too.
I have a hard time. You call a phone and it says it's being recorded, right? And you know it's being recorded. It wasn't the first time she used that phone. And you forget to hang up, or you don't hang up like you're supposed to, and you say things that you know that phone could be recording. You've lost the expectation of privacy, you know?
And I would add to that, there are other legal things going on with regard to whether you even have a state actor in here. But the Fourth Amendment has never been interpreted to protect people who are stupid or negligent. That's on them.
Well said. Look at this. This is actually really interesting. Wish I thought of it, but I'm not that smart. Such irony that her honorable son, Rob, is an ear, nose, and throat doctor. And this is what she's complaining of. There's got to be like a Freudian angle here in some way. Look at this. Love the assassination. Joel, isn't that the truth? Huge ears, small heart, but small ear canals. I'll give her.
Hey, Joel, if her ears are so bad, they can take her to a medical facility and have that done under escort, and they could probably bill her because she's got money. So that's what the states say. Fine. She wants to go to an ear, nose, and throat once every 3 weeks. She'll pay for it. We'll have her transported.
And in fact, that's what they say in their motion. If it's denied, then she's going to need to be escorted outside the jail to get the professional medical attention she needs.
Yeah. By the way, what about Joe? What do you think about, because people were saying not necessarily calling Rashbaum as a witness per se, but at least to depose him, to get the story on record under sworn testimony. What do you think of that? Is that a possibility that he's deposed?
Tim is right. They can't have it both ways. If he was actually her lawyer at the time, he may be under some risk with regard to representation at the time. If he wasn't her lawyer, then he's like anybody else who has relevant evidence that they can go after. So I don't see any reason why they couldn't depose him.
Yeah, I don't think he was her lawyer at the time.
Right, it was not.
But that's a loose thing. So Charlie's convicted. She thinks she may be a target of the investigation. Did she retain him to represent her, Or did she believe that he was her lawyer when they were, that's the communication, right? Did
That's
she
true.
believe when she was talking to him that it was the attorney-client privilege? That's the
Didn't
standard.
Joel, didn't he say something about this when you did that interview with him? I think
Um,
you asked him about this, and
you know what? I have to go back and watch it. I don't remember. I did. I think I'm almost sure I did ask him. And I'm sure he skirted around the answer. But if anyone knows, please let me
No,
know.
no,
But I
he
have to
gave a, I won't say a smug answer,
go. Mhm.
that she wasn't under arrest. We checked.
Right,
I
right,
told
right.
her there was no warrant keep her from traveling, that she could travel.
Yeah, with a one-way ticket. I mean, talk
Yeah.
about yeah, that's
that
a
was my favorite part of the motion, by the way. The description in here that they give of the evidence that she was going to take a vacation to Vietnam. I would not have put, not when the judge is going to be deciding this, is so familiar with the case, but that's their language.
Yeah. She did call a friend in Vietnam. It was Charlie's friend, Scott Radius. Is he going to be called, Tim?
He could. Yeah, I think he
Yeah.
will. He might be
And
called at the suppression hearing.
there were
Yeah.
two people in the room when she was on that call with Daniel Rushbaum,
That's right.
two friends
Yes, that is
who
correct. Great point.
also can report about anything that whatever the extent to which there might be a claim, and I don't think there is, on the Fourth Amendment issue with the call continuing to record. The two people in the room while she's happily divulging information were there. There was no recording there, and she wasn't under any compulsion by anybody to talk to them or talk in front of them.
I think
Yeah.
there's some, I know there's some evidence and it's not been reported, but Donna didn't even pay for the tickets.
Ah,
Yeah.
She had a
Yeah.
third party do the tickets to
But she,
protect her.
however, she is seen on WhatsApp messages talking to Indochina Sun Travel directly. So that could
Yeah, but
definitely
the third party who bought the tickets can be called as a witness.
sure.
very interesting. And Tim, is it safe to say that your pal Newland in the SAO's office, that he knows who those other two people on that call what are?
I'm sure
We
they
know.
do.
We
I'm
know it's
sure.
a Sarah somebody. I saw it in
Yeah,
something in
I think
writing.
it's listed. It was listed
Yeah.
at a hearing.
What about the emotional pain she caused? The mark. I'm looking at some of the comments here. So, Tim, one of the other arguments on the bond hearing, and then we'll do the jailhouse call super quick, and then I got to run because I'm taking my son to T-ball. We'll be back at 5:30. It says that the defense highlights that Dan Markel was murdered in 2014. Donna was not charged until 2023. That's 9 years later, suggesting that law enforcement did not consider her an immediate risk for nearly a decade. They argued that this undermines the idea that she is a flight risk or danger to society. But Tim, doesn't that all go out the window with what we were just talking about? I mean, these multiple witnesses who know or heard that she was planning to go, including possibly her own attorney, that she was trying to run to Vietnam via Dubai.
You're not get charged with a crime until the state believes they have enough evidence to prosecute you. And just because they didn't have enough evidence back then doesn't mean she wasn't a risk of flight. It just means later, when she got to become a risk of flight, she fled.
You tried.
Right? So, that's a funny one in that motion.
Yeah. So let me just read a little bit from the second motion. Now, this is the so-called hot mic call that they want, suppressed and or removed. But Donna Adelson, it's written in the motion, accepted the jail call knowing it would be recorded, but her consent was limited to the duration of the call with her son. Defense is arguing that once Charlie was disconnected, the legal justification for recording no longer existed, making any continued recording an unlawful interception. Florida law prohibits the unauthorized interception of oral communications and conversations in private homes. They are typically protected. The recording of Donna's conversation with Charlie dropped off would require a warrant, which is never obtained. Joe, you mentioned the Fourth Amendment.
Yeah. They're at least combining two or three separate legal arguments in a creative way there. Typically, you need a warrant unless there's an exception to the requirement to get a warrant. And one of the exceptions is a jailhouse call from an inmate calling out. That inmate has no expectation of privacy, and the person speaking to him, particularly when the person is informed by a recording that it's being recorded, has consented to it. So that part of it, you don't need a warrant because it's a jailhouse call, and she's told. Now they want to say that when the call dropped off and she kept talking, that somehow the state is responsible for the fact that she kept talking. There was no individual autonomy there. The call dropped off and she kept talking. She didn't take any precautions to make sure that phone call was done. So I truly do. There is, as I said at the outset, I don't know of a case that talks about this on the precise ground of this one, but they are pulling in Fourth Amendment law from 3 or 4 different places and knitting it up in a way that I don't think is going to fly. And I certainly don't think that, no, not that I know the Florida legislature, but I say this anyway. I certainly don't think the Florida legislature in enacting that Electronic Surveillance Act had this particular combination of circumstances in mind.
If the Fourth Amendment prohibits the government or the state, I
Right.
think the people running the phone was a third party. It wasn't the government or the state. The phone is just provided by a third party company that contracts with the jail. It's going to
Yeah.
be hard pressed for them to claim that the state, either
Well,
the state prosecution, Jason Newland or Georgia, had anything to do with
Yeah,
how that was
I
done.
think their
the-
argument is going to be that the private company is working at the behest of the state in the way that a private company can do security at the jail. And that's not going to insulate if there's misconduct caused, not going to insulate, the state actor part of it. It's just that there's so many little pieces that they have to put together in unique ways and then tie it together to get to the result. I just don't see it happening. Just don't.
yeah, and this is interesting. So, the state apparently might cite a case known as Jatar versus Lamiletto from 2000, which holds that conversations about extortionate threats are not protected. That's interesting. And then there's a technical argument potentially to be made by the state. This is going to happen, I think, during this next hearing. And it revolves around the exact nature of how the call was recorded. If the recording system was still engaged as part of jail policy, the
Right.
state may claim that the consent still applied. I think that's what Tim was mentioning. So if it's still if it's still activated or recorded on the jail side, it sounds like it's a moot point that it's going to be allowed in. Am I reading that right, Tim Jansen?
I think that's right. Just because Charlie hangs up and she keeps talking doesn't mean what she says on the phone is not is privileged. It's not privileged.
Particularly
So
in a context in which he's talking in front of 3 other people, her
right.
husband and the 2 others. Your claim that you've got a reasonable expectation of privacy on that phone call with regard to the 3 people in the room seems to me to be silly.
Yeah. Well, let's make this. Look at this question. Tim, how do you answer this one? Does Tim get grief from local legal peers for being on the podcast often talking? Do they make fun of you, Tim Jansen? I know they notice you in the supermarket, but do they make fun of you?
No, I was actually sitting right next to Josh and I did my cases. And in the middle of doing my cases, somebody from the jail was talking. And I said, "Hey, was that your client talking?" And he goes, No, that wasn't my client. That was somebody at jail. But no, yeah, no, I don't personally attack them. I'm giving analysis of the case and the legal issues. I don't personally attack any lawyer. I just call it like I see it on the issues.
Yeah. So final question to both of you, Joe Potuto, and then we're going to pick it up at 5:30 and we'll fill in the gaps. But at this point right now, what do you think is the single most incriminating piece of evidence against Donna Adelson that they're, at least going to attempt to suppress? Is it the trip to Vietnam?
Well, yes, Because, well, I would have said that even if I knew what the other things were. Seems to me this one is pretty, it's the one critical piece of evidence out of her own mouth that really points to guilt in the crime. There's a lot of other stuff you can put together. There's a lot of circumstantial evidence that I think is pretty persuasive, but this is the one piece that really drives it across the finish line by quite a bit.
Yeah, interesting. Buttercup 203 here. Tim, will Donna's husband, good old Harvey, wonder if he's having ear canal issues. Will Donna's husband be called to testify? He's left all alone because apparently, unless he went with Wendy to Austin, Texas. But will we see Harvey take the stand as a kind of a character witness to say what a wonderful woman Donna is?
I do not think they're going to call Harvey, because he's open to subject to cross-examination. Then they could get information about the trip to Vietnam through Harvey. So I don't think so. I don't think they're going to call Harvey. I don't know what benefit he would give, to tell you the truth.
Look at this final comment from Ned Smith, who has a bun up with a sewing needle in it. Tim looks so professional. So does Joe. But if you notice, there's no Joel. Ned, I still love you, even though you think I don't dress professionally. I dress like the hip tech guys. That's what I do. I take my lead from them.
So, Joe,
yeah.
The biggest piece of evidence is going to be when the judge gives an instruction to the jury
Mhm.
that you can infer consciousness
Right.
of guilt by flight.
Mm.
And they read that and they hear that. It's so damaging to a defendant. If there's
Yeah.
any kind of borderline maybe here, that's going to tip them over the edge. Consciousness of guilt.
Very interesting. That's it. When he says that, could be game over. No moss. That's it. Donna's cooked, but still a bit of a ways to go. It's hard to believe that I like the final case management hearing, or the deadline for discovery. It's so weird that April 30th is only a few months away. What's going on with time? That's a whole other show. We're going to have to discuss time. What is time? Is time real? Is time fake? Look at Tim Jansen. He doesn't look a day over 43. Time is not caught up with him. I'm starting to get that neck wrinkle, so time is catching up with me.
You need to buy a book by Einstein. By Einstein.
Yeah,
And
Joe,
then you can learn about time.
You look like you started teaching in 2014, and I won't say when you actually started. Yeah, but I won't say when you started your first year. But you look fantastic, and everyone loves your flowers on both your lapel and behind you. So we're gonna come back at 5:30. We'll hash this all out. We'll open it up to you to ask questions. Thank you for being here. That was Donna Adelson live in court for. Well, she wasn't, but her attorneys were for just a couple of minutes. And as you can tell, there's motions being filed and more to come. We'll stay on top of it. Love you all. See you at 5:30. Love you, Tallahassee. Love you, Jersey. And justice for Dan Markell.